Hi, my name is Jeffrey Solomon. As a bankruptcy attorney in South Florida, all clients, of course, want to know if they will lose any property if they file bankruptcy. Individuals may keep what are called exempt assets. In most cases, the debtor does not lose any property to the bankruptcy trustee. I will briefly describe and discuss the exemptions that are available to Florida residents who have resided in Florida for more than 2 years. If you move to Florida within 2 years prior to filing bankruptcy, then you cannot use Florida exemption law in bankruptcy cases. The issue of what exemptions you can claim is then more complex and beyond the scope of this short video. If you are a Florida resident for 2 years, you can keep retirement assets, such as 401ks, IRAs, and the cash value of an insurance policy on your life. This provides an extremely large protection to Florida debtors. However, Florida only protects $1,000 in personal property and $1,000 in the equity or value in a car. You can retain an additional $4,000 in personal property if you do not retain the benefits of a homestead. This issue can be complicated as to homeowners who have no equity in their homes. You should consult an attorney on that issue. Florida is famous for providing unlimited protection for the homestead exemption. Though this is generally a correct statement, there are some limitations in bankruptcy depending on how long you have owned the home. Additionally, for any exemption issue, there is a concept called fraudulent transfer. For example, if an individual takes cash savings and buys an annuity to avoid paying creditors, then the bankruptcy trustee may be able to set aside the transfer and seize the annuity. Keep in mind that the homestead exemption for the home or real property in the state of Florida is only 1/2 acre within the city limits. I like to remember the following numbers: 91, 730, 12, 15, and 10. An individual who moves to Florida can file bankruptcy in Florida after being a resident for 91 days, but must wait 730 days to be able to use the homestead exemption in Florida. But the individual still does not receive the full homestead protection in bankruptcy court unless the property has been owned for 1,215 days. The current exemption for property owned less than 1,215 days is only $146,500, though this amount would be doubled for husband and wife. It is very important that under Florida law this is fully exempt, but in bankruptcy law there is a 10-year fraudulent transfer period as to homestead. This means that if you take an exempt savings to buy a homestead or pay your mortgage in advance instead of paying your debt, the bankruptcy trustee can go after your homestead. Finally, there is an additional protection in Florida for property acquired jointly and in the name of husband and wife. This is called tenancy by the entireties. A creditor of one spouse cannot seize the joint asset. This protection applies in bankruptcy cases in Florida as to Florida property. Be sure you speak with an attorney to determine if your property is properly held as tenancies by the entireties. The bottom line is that it is necessary to consult with a bankruptcy attorney to determine what property you can and cannot keep. Please contact me for more information. Thank you.